knowledge of person and the resource person of the state from Mr. Sailesh Gandhi, I believe that everybody would be gaining with the today's session. We have already shared the notes with him, shared the notes which he had shared with us in the different WhatsApp groups as well as on the Telegram. Similarly, he has also shared with us some PPTs in respect of the RTI, which we will be sharing after the webinar is over. Today, he will also be sharing those PPTs by the screen sharing in the today's webinar. On behalf of Beyond Law CLC, we are thank you to Mr. Gandhi, who has been kind enough to share his vast practical and personal experience. And it's a rare occasion where a person who has seen the both sides as while adorning and deciding, as well as to how these could be used as for a common man also. Without taking much time, I would request Mr. Gandhi to explain all these three aspects. Yeah, thank you, sir, once again.
Thank you very much, Vikasji, and thank you for inviting me to share my thoughts with this audience. I'm very grateful for this. Fellow citizens of India, we say that India is the world's largest democracy. When I was in school, I was taught that democracy is rule of the people, for the people, by the people. But it does not appear to be true in India. Just give me 10 seconds. Sorry about that. Question is this rule of the people, for the people, by the people? If you go to any government office, does an average citizen feel that he is or she is the ruler of this nation? The answer across the country is no. Then how do we claim we are the world's largest democracy? Based on what? I would submit to you that we say we are the world's largest democracy because we have a reasonably fair system of elections by which we are able to change governments, change leaders, change our political representatives. Having a fair system of elections and a constitution are necessary conditions for a democracy, but are not the complete set of conditions. The heart and essence of democracy is the concept that each individual citizen is the sovereign in her right, and she gives a part of the sovereignty to the state in return for which she gets the rule of law. Sovereignty of the individual is the key to a democracy, is the heart of democracy. Democracy is rule. The word is R-U-L-E, rule, of the people, for the people, by the people. In Hindi, we use the word Lokshahi. Lokshahi can only have one meaning, logo ki shahenshahi. You, friends, should feel like a Badshah or Begum when you deal with the government. At one college, when I was talking like this, one young student got up and challenged me. He said, Mr. Gandhi, is it possible to run a nation with 140 crore Badshahs and Begums, rulers? In some extent, it happens, and therefore, I'd like to give you two examples to justify this statement. In the United States of America, I'm not saying everything there is good, but in terms of democracy, they have a 2-century lead over us. An immigrant from India, Pakistan, Bangladesh, China, wherever, if he or she has applied for the green card or the citizenship of the United States, will easily pick up a telephone to ask about the status of his application. Whether the application is being considered, whether there are any defects in it, when is it likely to be considered, so on and so forth. And 99%, he or she will get a rational answer from the other side of the telephone because a human being has called. You are all first-rate citizens of India. If you applied to change the address in your ration card and you do not get a reply, most of you will not pick up the phone to try and ask about the status of your application. Even if you go there, your chance of getting a rational answer are 50-50 only. That is the important part. The basis of human beings as rulers, as democracy, is a fundamental basis. And one more example, I'd like to give you a story that all of you know, but look at it from a slightly different perspective. Over 125 years back, in South Africa, Mohandas Karamchand Gandhi got inside that train in the first class compartment. He had a first class ticket. But the white man objected. Hence, the police, the railway official took him off the train. In that same story is written that Mohandas Karamchand Gandhi complained about what had happened to him by telegram. And in 12 to 14 hours, a railway official came and put him on the next train. Think of the significance of this story. Mohandas Karamchand Gandhi was not a citizen of South Africa. Mohandas Karamchand Gandhi, by the South African law, then was a second-rate human being. Even as a human being, he was treated as a second-rate human being because he was not a white man. Despite such a law, when he complained, the system responded because one human being had complained. Today, in the Indian Railways, if you file a complaint in 12 to 14, forget 12 to 14 hours, in 12 to 14 days, if you get an acknowledgement, you will consider yourself pretty lucky. Respect for the individual is the fundamental of democracy. Respect for the individual is a fundamental thing without which there can be no democracy, there can be no monitoring, there can be no better governance. That is the belief that people who believe in democracy have. And right to information indirectly empowers the citizen to make him or her powerful enough to challenge the system, to demonstrate that he owns the government. In a democracy, you and I own the government. Each individual owns the government, not just collectively. Each one of us owns the government. Again, when I was talking like this at one college seminar, one student got up and said, "Sir, aap sahi keh rahe hain?" I said, "Haan ji." He said, "If I like a government car, can I take it home?" I said, "You can't take it home." He said, "Then you are lying. You said I own the government. I'm the ruler of this government. Then if I like a government car, why can't I take it home?" The answer I told him was that he owned it with 140 crore other Indians. It was a joint ownership. And therefore, if one person takes it away, it would deprive the others. But, and this is important to understand, the information in the cupboards, files, computers of the government also belongs to each one of us. We own it. Therefore, the default mode is information belongs to us. And if that information is given to us, it does not deprive anybody else. Therefore, right to information converts the concept of democracy into an actual practical thing. And one individual, we need not be in a mass of people. We need not be 50 people, 5 people, 10 people. One individual asks for information which is on government records, and that must be provided on pain of penalty. Worldwide, such a transparency law first came in Sweden on 2nd December 1776, 250 years back. After that, for nearly 150 years, no other country passed such a law. And in the last century now, over 120 countries have such a transparency law, which goes by 3 different names. FOI, Freedom of Information, RTI, Right to Information, and ATI, Access to Information. These are the same words used in different countries for this. In India, the first movement appears to have started in rural Rajasthan, when a combination of 3 unique people got together. Aruna Roy, an IAS officer who at a young age gave up her job to serve people in the village. Nikhil Day, a lawyer about 20 years younger than her, who had qualified in the United States, decided to join her. And Shankar Singh, a man of rural Rajasthan, who was an excellent communicator. These 3 people got together and started explaining the concepts of democracy to people. And from there, the right to information movement grew. Then, of course, lots of people joined it. And ultimately, on 12th October 2005, the right to information became a national act operation throughout the nation. And incidentally, 12th October 2005 was Vijayadashmi. It was a very significant day. It was not planned like that. It just happened. This is a powerful tool to bring actual democracy to India. This is a powerful tool to empower the citizen. And keep remembering this. And I hope at the end of this talk, you'll have picked up something on right to information. But more importantly, you will get up believing that you are the ruler of this nation. You are the Badshah or Begum of this nation. Now I go through some of the provisions of the law and try and explain the law from my perspective. Mr. Vikas, I have screen sharing permission. Can you see the presentation? Okay. Right to Information Act 2005. Let's look at the preamble of the law. Whereas the Constitution of India is an established democratic republic, and whereas democracy requires an informed citizenry and transparency of information which are vital to its functioning, and also to contain corruption and to hold governments and their instrumentalities accountable to the governed. And whereas revelation of information in actual practice is likely to conflict with other public interests, including efficient operations of the government, optimum use of limited fiscal resources, and the preservation of confidentiality of sensitive information. Parliament was aware that there may be some practical difficulties in sharing information with citizens, but it recognized that citizens are the owners and rulers of this nation. And whereas it is necessary to harmonize these conflicting interests while preserving the paramountcy of the democratic ideal, that is what the RTI Act is. The harmonizing has been done by the law. There are some people who say, oh, we will harmonize. No, the law has harmonized it, Parliament has harmonized it, and the provisions of the law must be followed. What is information? This is extremely important to understand. I've seen people who've used the RTI Act for a number of times, but have never understood this. Information means any material in any form, including records, documents, memos, etc., etc., and information relating to any private body which can be accessed by a public authority under any other law for the time being in force. In simple terms, if I put it, what it says is information must exist. What exists is information. What does not exist is not information. So if you say, what is the meaning of a law? That is not information unless there is a record which says what is the meaning of the law. If you ask, if I apply for a job, will I get it? That is not asking for information, because that is, you are actually interrogating. RTI is right to information, not right to interrogation. This is extremely important to understand. And information relating to any private, RTI applies to public authorities. What is a public authority? We'll see soon. Other private bodies which are not covered by the definition of public authority do not come under the ambit of RTI. However, information that they supply to a public authority, which can be accessed by a public authority, has to be accessible by the citizen also. The principle is you own the government, everything in government is yours, everything private is not necessarily yours, but if it belongs to the government, you have the right. Who has to give information? Public authorities. Section 2(8) defines this. Public authority means any authority or body or institution of self-government established or constituted by or under the Constitution, by any other law made by Parliament, by any other law made by state legislature. The first three cover almost everything that we consider as government. Municipal corporations, state governments, central governments, panchayats, all of these are covered by 1A, B, and C. Also, there are some bodies that are created by an act of Parliament or legislature. For example, the Sikh Gurudwara Prabandhak Committee has been created by an act of Parliament. So that's a public authority. D says by notification issued or order made by the appropriate government. If some body is created by notification specifically, for example, all deemed universities are created by a notification issued by government and therefore they are public authorities, and includes any body owned, controlled, or substantially financed. Non-government organization substantially financed directly or indirectly by funds provided by the appropriate government. Because somebody seems to be fooling around, can you please do something about it? I'd be obliged if you can do something. Now, there's been some controversy about the PM CARES Fund. They are saying PM CARES Fund is not a public authority because they consist that it's not financed by government, that it's not owned by government, and nor is it controlled. They've specifically written that it will not be controlled to stay out of RTI. However, think carefully. The trustees of the PM Cares Fund, the chairman is the Prime Minister of India, 3 other ministers are ex officio trustees of the trust. When they represent the government in its official capacity, they cannot claim that it's a private enterprise. The control is on behalf of government. It would be a slur on their integrity to claim that they do not represent the government through. Therefore, it is being controlled by government and therefore is certainly a public authority and must follow RTI Act. Section 2J, RTI Act. Right to information means the right to information accessible under this Act, which is held by or under the control of any public authority, and includes the right to inspection of work, documents, records. You can inspect documents, you can inspect records, you can inspect works. What exists, I repeat, is information. Therefore, a road that exists, a building that exists, one young chap in Mumbai decided to inspect a government hospital. That is also part of RTI. Taking notes, extracts, or certified copies of documents or records. This is what most of the time people do, taking photocopies of records, taking extracts from records, and so on. Taking certified samples of material. You can also take samples of material. For example, if you believe that a government hospital has got fake medicines, you can take samples and get it tested. If you believe the concreting being done in a government job is of poor quality, you can take a sample again and get it tested. Obtaining information in the form of diskettes, floppies, tapes, video cassettes, or any other electronic mode, or through printouts where such information is stored in a computer or in any other device. You can take information on a computer, on a hard disk, or on a pen drive, or also on a hard copy. CCTV footage is also included, and this can be a very vital source of information increasingly, since many public places are covered by CCTV. Most important section in the RTI Act, in my opinion, is Section 3. It is the shortest, but is very, very meaningful. Subject to the provisions of this Act, all citizens shall have the right to information. Who will have the right to information? All citizens of India, because they own the government. Those who are not citizens of India do not own the government. They are not rulers of this nation. Citizens of India are rulers of this nation. Can any information be denied? That's a philosophical question. If I own in my house, I can open any cupboard, any drawer I like, and nobody can stop me. I don't need any permission. I don't need any locus standi. Then in the government, if I own the government, all information should be available to me. However, it is felt that some information should not be made available because it would harm certain interests which need to be protected. And that is specified in Section 8 and 9 of the Act. Section 9 covers copyright. So anything that is copyrighted, you cannot say, I should get copies of that. Section 8.1 has 10 exact provisions, exactly 10 provisions. Though that is information that shall not be given. Can anybody say this information is confidential and hence not given? The answer is no. It must be covered by Section 8.1, 10 provisions, and we'll deal with that a little later. Section 4 is the heart of the RTI Act. Every public authority shall maintain all its records duly catalogued and indexed in a manner and form which facilitates the right to information under this Act and ensure that all records that are appropriate to be computerized are within a reasonable time and subject to availability of resources, computerized and connected through a network all over the country on different systems so that access to such records is facilitated. This was a promise of the law. All records should be kept properly, etc. Yes, but are appropriate to be computerized within a reasonable time. 16 years is a reasonable time. Today, all government offices have got computers. All subordinate courts have got computers. Gram Panchayat offices have got computers with internet connectivity. What is the actual truth? Quite often a citizen goes to a government office to follow up on an application or complaint or representation and is told, file nahi milta hai. File is not available, not traceable. To pay 100 rupees, the file may surface. You pay 500 rupees, the record can be changed. Pay 1,000 rupees, the record may be removed. Maybe for 2,000 rupees, the entire file can be made to disappear. All this can stop. What is the promise of this? That all work would be done on computers. Even today, all letters are being typed on computer. And the files would move electronically. If it moves electronically, changes are not possible to do. They can be caught. Any change in a file can be identified with a person. Today, our banking industry runs purely on internet. This can happen in government also. If a file originates in one place and has to travel, today the file physically has to travel. Electronically, it could travel in 5 different cities of the country and the result can come back in less than an hour. The efficiency would go up. Corruption would be curbed by at least 30%. At least 30% of our corruption takes place by fooling around with files. And equally important, we would save thousands of crores of rupees on paper, files, space to keep these files, cost of trying to locate files which get lost. All of this can change, provided we work only on computers, and that is possible. That is not difficult. Resources exist, only the will is not there. We can curb corruption. Forget Lokpal. Lokpal will do nothing. Just by getting everything on electronic, paperless, we will save thousands of crores and we will save a few billion trees every year. That is something that we can do. Unfortunately, this has not been done adequately. There are 16 points in section 41B 17. Such other information as may be prescribed. The heart of the RTI Act, unsatisfactory implementation. Computerization is the heart, in my opinion, which could make things automatically transparent. And every evening, work done in an office can be on the internet. So that the default mode is recognizing that the citizen owns the information and it should be available. It would also make the job of public officers easy, public information officers. Over 50% applications seek information which should be available under section 4. Unfortunately, this is not happening, and that is why the RTI applications are growing. Every public authority shall within 100 days, which is long back, designate as many officers as the PIOs, Central Public Information Officers or State Public Information Officers, in all administrative units or offices under it as may be necessary to provide information to persons requesting for the information under this Act. Fine, we know who has to give information, public authorities, but how do we access it? Who do we see? Do we go about finding out? No, the answer is the Act says all administrative units of a public authority shall have a person designated as the public information officer. He's generally a person who's doing something else, but is also given the job of being a public information officer. And therefore, you need not worry about who the public information officer is. You just need to write to the public information officer, think of which public authority is likely to have the information that you are seeking. Likely to. Apply to the public information officer of that public authority at that office. Supposing it is not in that office, then what happens? If it is in the same department, the law requires that this should be accessed from the other departments and given to you. If it is a completely different department, supposing you asked a RTI query which you believe genuinely should be with the police, but is actually with the municipal corporation, what should happen? Can they return it? The answer is no. You are recognized as the ruler of this nation. Therefore, the law requires that the application must be transferred within 5 days by the PIO to the right PIO. Your position as sovereign of this nation is actually actualized in this law. A person who desires to obtain any information under this Act shall make a request in writing or through electronic means in English or Hindi or in the official language of the area in which the application is being made. Many government departments today and many state governments have got RTI online also, so where it is easy to make an RTI application online. Incidentally, no form is required. Some people follow a format which you may follow, and In most cases, the application fee is 10 rupees. You can make the application in English or Hindi or the official language of the area in which the application is being made. But you cannot insist that you must get a response in the language you choose. The response can be in any one of these three. An applicant making request for information shall not be required to give any reason for requesting the information or any other personal details except those that may be necessary for contacting him. Many government officers feel this is not correct. Why should somebody harass us without any reason? You must give a reason for asking. And a lot of people have said this is a fault in the law. Please remember, right to information is a fundamental right of citizens under Article 19(1)(a). If I have to give reasons for seeking information, I'll have to tomorrow give reasons for speaking. I'll have to give reasons for writing an essay, for publishing something. For none of these do I need it because it's my fundamental right of expression. This has been recognized by the Supreme Court, and it's very unfortunate that sometimes even court judges make such remarks in a frivolous manner. No locus standi is required. It is your right because you own the information, I repeat. On receipt of a request under Section 6, PIO shall as expeditiously as possible, in any case within 30 days of the receipt of the request, either provide the information on payment of such fee as may be prescribed or reject the request for any of the reasons specified in Section 8 and 9. I repeat, Section 9 is to do with copyright infringement. So if somebody's, for example, if you ask censor board and said, I want a DVD of a movie, that may be denied to you because it would infringe somebody's copyright. Apart from that, Section 8, 10 sections is all you need to know. Section 8(1) is 380 words to be exact. That is the only information which can be denied. Default mode is all of the information belongs to you. If PIO fails to give decision on the request for information within the period prescribed, which is 30 days, PIO shall be deemed to have refused the request. And this means a refusal without reasons. And that invites the penal provisions of the law. Now, the way the law is structured, you file an application generally with a 10 rupee Indian postal order or RTI online. The first day is the day the PIO receives the RTI, the PIO's office receives the RTI application. Then, supposing the information you are seeking is 200 pages, the PIO can charge you at the rate of 2 rupees per page. So 200 into 2 rupees, 400 rupees, he will send you a letter. The moment he sends the letter, the 30-day clock stops. Then when you pay the money, 30-day clock starts again. But if person making request for the information shall be provided the information free of charge, when a public authority fails to comply within the time limit specified in subsection 1. If in 30 days the information is not given, even if the information is 1,000 pages, the public information officer cannot charge you for it. 30-day period, I thought I'll just explain in another manner also. PIO receives RTI application day 1. After X days, PIO sends letter asking additional fees, 30-day clock stops. Additional fees paid, 30-day clock starts again. Information sent after Y days, X plus Y less than or equal to 30 days. If RTI application is transferred, as I said, if in a different department, the RTI application is to be transferred, they get 5 days for transferring, so the period becomes 35 days. Now, I've given some samples of RTI applications. A good RTI application is focused. Think of what is your objective. You don't have to explain the objective, but you have an objective in mind. You think something is wrong, you want to expose it, you feel you want to pressurize because your application is not being responded to, an investigation that you have asked for is not happening. Whatever it is, you have something in mind. Focus on that and make it as short and focused as possible. The law doesn't say anything like this. But I've seen RTI applications which go rambling, which don't achieve anything. I've given some instances of RTI applications, which I'm not going to read out. This presentation is going to be shared with all of you. Take a look at it. It's pretty focused and it is obvious that there's a purpose. Just to give you one example, number 2, I want a copy of the minutes of the meeting of the public hearing Gram Sabha held on 15/7/2019 along with the file notings and comments of the officers. That's all. That's an RTI application. If there are any norms for inspection and maintenance of roads, I want a copy of the same and designations of officers responsible for doing this work. If there are inspection roads of the roads, I want a copy of these as well. Short, brief, focused. That makes it difficult for a government officer to try and dodge or say, I did not understand what you meant. A good practice initially, if you have not used RTI extensively earlier, is to make the RTI application draft and show it to your wife or friend or somebody and see if it makes sense to them. Sometimes you have in mind what you want, but you're not able to put it in words. And when you don't put it in words, even an honest public information officer is not able to help you. These are, again, for example, a simple one. If you want to inspect files, here's a suggested format. I want to inspect files relating to so-and-so. I will bring Mr. So-and-so to assist me in the inspection. Please suggest 2 dates of the time at which I could come for the inspection. I will identify the documents for which I want photocopies at the time of inspection. Please ensure that the pages of the files are numbered. When you go for an inspection, insist that all pages must be numbered. Otherwise, they could have taken out some information and you will not know what happened. Now, here again, I want to remind all of us, RTI is a fundamental right of citizens under Article 19(1)(a), which guarantees freedom of speech and expression. Various Supreme Court judgments have held that this includes the right to information and right to publish. Please pause for a while and ask yourself, we say media is an important pillar of democracy. Is the media mentioned in the Constitution of India? The answer is no, it is not mentioned. Then where does the power and the recognition for media come? It comes from Article 19(1)(a). Courts have held that media is a business like any other business and therefore deserves no specific protection. But it is the medium through which citizens get information. Therefore, media is very important. Now, if a fundamental right is given to me, restrictions have to be in the Constitution of India. It cannot be imposed outside. The only permissible restrictions are given in Article 19(2), which permits reasonable restrictions in the interest of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation or incitement to an offense. As per Article 19(2), only in these matters can any restriction be put on my fundamental right under Article 19(1)(a). Right to speak, right to publish, right to information. These are at par and at one level according to Supreme Court judgments and the Constitution of India. Now we'll take a look at the exemptions in the law. Exemption from disclosure of information, Section 8(1). Notwithstanding anything contained in this Act, there shall be no obligation to give any citizen information disclosure of which would prejudicially affect the sovereignty and integrity of India, the security, strategic, scientific, or economic interests of the state, relation with foreign state, or lead to incitement of an offense. Quite often, this is put as an omnibus exemption, which is wrong. They must identify whether it will affect the sovereignty and integrity of India, or the economic interests of the state, or relation with foreign state, or lead to incitement of an offense, and give some rational explanation. That is necessary when an exemption is claimed. 8(1)(b). Information which has been expressly forbidden to be published by any court of law or tribunal, the disclosure of which may constitute contempt of court. Quite often, when a matter is sub judice, PIOs deny information saying the matter is sub judice, hence we will not give it as per Section 8(1)(b). Wrong. That is not as per the law. The law knew the word sub judice. Parliament was aware of the word sub judice but did not use it. What Parliament said is information which has been expressly forbidden to be published by any court of law. So if somebody is claiming exemption under Section 8(1)(b), he or she must be asked to give the exact citation by which this information is not to be given. Otherwise, if there is no specific court order, the information must be given to you. C. Information, the disclosure of which would cause a breach of privilege of Parliament or state legislature. For example, before the budget is announced, if you ask for budget papers, that would infringe on the privilege of Parliament or state legislature. Similarly, Commissions of Inquiry Act says that within 6 months, from the submission of the report must be placed in Parliament or state legislature. So before 6 months, you cannot get it, or before it is placed in Parliament or state legislature. But, and here is an important part of this, quite often commissions of inquiry reports are made and put away if they are inconvenient to the government in power. Other scam in Mumbai that had occurred, I noticed that the inquiry commission had given a report. In 6 months, they did not place it in the floor of the state legislature. So I asked for a copy of the report. They claimed it is breach of privilege of legislature. I countered in the appeal that once the period of 6 months is crossed, you already breached this privilege of the state legislature. You now cannot claim breach of privilege, and they had to give the report to me. Information including commercial confidence, trade secrets, or intellectual property, the disclosure of which would harm the competitive position of a third party. There's a larger public interest override, which we'll deal with later. Two conditions have to be satisfied. It should be in the nature of commercial confidence, trade secret, or intellectual property. That means information which normally would not be disclosed. And it must harm the competitive position of a third party. Unless both conditions are satisfied, 8(1)(d) cannot be claimed. For example, if you ask for the formulation of Coca-Cola, it may be denied to you because it clearly falls under this. However, Bank of India can claim this for information relating to its competition. But Indian Railways cannot claim it since it is not in a competitive field. Before a tender is allocated, this can be claimed. Once the tender is allotted, this cannot be claimed because it will not hurt anybody's competitive position. Information available to a person is fiduciary relationship. This is a very commonly misused exemption by PIOs. They say that somebody has trust in government, therefore it's held in fiduciary relationship, which is wrong. Merely having trust is not the condition. The conditionality for this is it is given by somebody to somebody with superior knowledge for his or her benefit. I go to a doctor, a lawyer, a banker for my benefit, and I give information for my benefit. B, I have a choice whether to give it or not. There is no law that forces me to give it. C, I have a choice of choosing whom to give it to. I can choose my banker, my doctor, my lawyer. And yes, I have trust in such a person because only then will I go to him. 99% of the information in government records, in public records, is not held in a fiduciary relationship. But quite often PIOs use this, and average citizen says, oh, kuch hoga, ye shabd to samajh mein nahi aata hai, but it must be something. Do not accept claim for such an exemption. Information received in confidence from foreign government. Notice carefully, only in one place is the word confidence or confidentiality used. When information is given by a foreign government and the government claims it is held in, it was given in confidence, then there can be no further arguments. The Rafale information was denied based on this argument. Information, the disclosure of which would endanger the life or physical safety of any person or identify the source of information or assistance given in confidence for law enforcement or security purposes. If disclosing such information is likely to endanger somebody's life, then it would be denied. H, information which would impede the process of investigation or apprehension or prosecution of offenders. Quite often, when an investigation is ongoing, they say we will not give information because there's an ongoing investigation. Wrong. They must show that giving the information is likely to impede the process of investigation. In 70% of the cases, somebody has filed a complaint and he knows that no investigation is progressing, so therefore they ask for under RTI saying, I want the progress of this complaint. And this 8(1)(h) is claimed. Wrong. It would be laughable to claim that the person who filed a complaint is likely to impede the process of investigation. Information must be provided unless they can show how it will impede the process of investigation. 8(1)(i). Cabinet papers, including records of deliberations of councils of ministers, secretaries, and other officers. Provided that the decisions of councils of ministers, the reason thereof, and the material on the basis of which the decisions are taken shall be made public after the decision has been taken, the matter is complete or over. This is a very interesting exemption. Up to a certain point, information is exempt until the decisions are taken. However, once decision of the Council of Ministers is taken, the decisions thereof and the material on the basis of which the decision is taken shall be made public after the decision has been taken. What is envisaged is, for example, when a bill is presented in Parliament, there is a discussion in the Council of Ministers between officers and the government and so on. Once the decision is taken to table the bill in Parliament or state legislature, once the bill is placed, the basis on which this decision was taken should be made public and made suo motu available on websites. The whole idea of democracy is citizens will discuss and debate the reasons given and the pros and cons of a bill. That is how democracy should work, not by suddenly passing bills in Parliament without any discussion. Citizens should also have a say in it. Citizens are the masters of this democracy, and therefore that is what this law recognizes. 81J. This is the most popular exemption, which is grossly misused by public information officers. Information which relates to personal information, the disclosure of which has no relationship to any public activity or interest, or which would cause unwarranted invasion of the privacy of the individual. Larger public interest override we'll deal with later. Provided that the information which cannot be denied to the Parliament or a state legislature shall not be denied to any person. Quite often, PIOs say it is personal information. Your name is personal, your age is personal, the color of your hair is personal. Anything, if you write a letter, who wrote the letter? Mr. X wrote the letter. So it's personal. It can be identified with a natural person. But being personal does not exempt information. Parliament specifically said, if it is personal information, it may qualify, but then it has to satisfy other conditions. The disclosure of which has no relationship to any public activity or interest. 99% of the information in government offices is the consequence of a public activity. Your private activity, you don't go and file. What I eat at home, I don't go and file with government. But if the government has paid the bill, then I may file the bill with government, and then it is a public activity. Or which would cause unwarranted invasion of the privacy of the individual. Now we have a slightly funny dispute, if you may call it. What is privacy? Everybody says privacy is a fundamental right as declared by a 9-judge bench of the Supreme Court of India in Putttaswamy's case. Yes. Read the whole judgment. You cannot figure out what is privacy. So how is a PIO supposed to? This confusion of what is a public activity and what is privacy the Parliament was aware of. Therefore, it put an acid test only to this provision. Provided that the information which cannot be denied to the Parliament or state legislature shall not be denied to any person. What this means is, if somebody claims exemption under section 81J and says, I will not give information because it is personal information, he or she must declare that in their opinion, whether it's a public activity or a private activity. For example, if you apply for a government job, that's a public activity. If you apply for a caste certificate, that's a public activity. That's not a private activity. Or is it an invasion on privacy? There's a lot of gray area and people may have different connotations on privacy, but it should be laid down in my opinion. However, it must be tested on this. Provided that the information which cannot be denied to Parliament or state legislature shall not be denied to any person. What this means is whoever is denying information under 81J, Public Information Officer, First Appellate Authority, or judge, must make a statement that in my opinion, I would not permit this information to be given to Parliament. Article 19.2 talks of permissible restrictions in Article 19.1a, and there are only two words that would meet privacy: decency or morality. If something violates decency or morality, it should not be given in RTI, it should not be given to Parliament or state legislature. Therefore, a rejection in 81J must state that I would not give this information to Parliament or state legislature. It's a subjective assessment. Notwithstanding in the Official Secrets Act 1923, nor any of the exemptions permissible in accordance with subsection 1. A public authority may allow access to information if public interest in disclosure outweighs the harm to the protected interest. Please note carefully, public interest is required to be demonstrated only if an exemption applies, not otherwise. Official Secrets Act 1923 cannot be claimed as a reason for denying information. Exemptions cannot be claimed unless a larger public interest is demonstrated. To give an example, Nirav Modi's company, you may seek information from Punjab National Bank about Nirav Modi's company's account. And it may be rightfully denied under Section 81E, saying it's fiduciary. And yes, information by a bank is held in a fiduciary capacity. But you could then argue that as per Section 8.2, because there is a major scam, this information must be released as a larger public interest in disclosure. And I would say this would fall in the gray area of the law. Section 8.1J, again, I have delineated just to explain that 8.1J denials, 90% of the denials under 8.1J are wrong and not as per the law at all. If the PIO does not respond to you or does not give you the information, what do? You file a first appeal to First Appellate Authority within 30 days for not getting information, incomplete information, or wrong information. First Appellate Authority should decide in 30 days, but he can extend it by 15 days by giving reasons. If result of first appeal not satisfactory, file second appeal to the Commission within 90 days. For state government bodies, there is a state commission. For the central government bodies, there is a central commission. I was a Central Information Commissioner. Section 19.5 says, onus on PIO that denial of information is justified. The law recognizes your right as your default right. If information is denied by a PIO, he has to justify why he did not give information. You do not, by law, require to explain why you want information. And I repeat, no larger public interest needs to be demonstrated unless an exemption is established. Only if an exemption is established is a larger public interest required to be demonstrated. Appeal. Carefully look at the response and see if information has been provided. Information can only be denied if it is not available anywhere. If it is available with another office, it must be obtained and given. If it is with a different department, the application should be transferred. Or if it is exempt under Section 8 or 9. These are the only reasons based on which information may be denied to you. Section 20 is the teeth of the Act. Without Section 20, this Act would have been useless. If information denied without reasonable cause, Commission must penalize the PIO, deemed PIO, rupees 250 per day of delay after giving an opportunity of explaining. Maximum penalty, rupees 25,000. Commission can also recommend disciplinary action against the officer and the compensation to be paid to the applicant. This, as I said, is the teeth of the Act. This is the reason why the Act works. Unfortunately, commissioners are rather lax in imposing penalties and treat it as if it's a capital punishment. It is not capital punishment. If without any reasonable cause PIOs deny information, they must be subjected to penalty. And this is the clause that recognizes the sovereignty of the individual citizen. There is no other law in India. Here is a law that says the right of one individual was without reason denied. Therefore, the public servant must pay a penalty from his or her own salary up to 25,000 rupees for this. This is like the sovereign of a nation. If he was denied something which was his rightful information, supposing Akbar Badshah or Shivaji Maharaj asked for some information from their courtier, the courtier said, "Nahi deta hu," they would have probably put them in prison. You don't get to put them in prison, but we get the satisfaction of being penalized. And that demonstrates your position as the sovereign of this nation. Section 22 is also very important. The provisions of this Act shall have effect notwithstanding anything inconsistent therewith contained in the Official Secrets Act and any other law for the time being in force or any instrument having effect by virtue of any law other than this Act. A lot of legal tangles come in because somebody says, oh, as per Banking Act, this is the position. Somebody says as per RBI law, this is the position. Somebody may say as per company law, this is the position. So you have to resolve between different laws. RTI Act was conscious of this, and therefore it said that this law overrides all other earlier laws as far as giving of information is concerned. let me clarify. Only in terms of giving of information does this law override everything else, not for anything else. It's not a grievance redress format. It's a information format. It's a law for giving information, not for grievance redressal. Though quite often grievances do get redressed, but by law, there is no provision that should give you redressal of a grievance. Appeals. RTI application information in 30 days. If no response provided or unsatisfactory response, first appeal to be filed within 30 days of response or 60 days in case of no response. Sometimes the question that comes is, if I'm not, where do I file my first appeal? The law requires the PIO to give you the information of the details of the first appellate authority. But if he has not responded to you or not given the information, then what do I do? A simple technique is to file an RTI to file the first appeal with the first appellate authority, care of public information officer, and send it to the same address. Below that, write that the law requires you to give me information about the appellate authority. Since you have not done it, you must not forward it to the first appellate authority. First appellate authority order after hearing within 45 days. If unsatisfactory order or no response, second appeal to commission within 90 days of first appellate authority's order or 120 days from the date of first appeal if no order is received from first appellate authority. Now, some states have formats which you can follow. You don't need to go anywhere to take a form. This is the format of Maharashtra. It can be used. Central government has no format. It can be like a straight letter, but you can also use this format since it's useful. This is a story that has happened thousands of times over. This is an actual RT application that was filed by a young boy from Vidarbha who had come to Mumbai looking for a job. Where did he stay? He stayed with an uncle of his in a slum. And while he was going around, he saw an RTI workshop being held. RTI workshops are held in various places, societies, clubs, associations, slums. So he sat down, he had nothing to do, he sat down and understood what is RTI. He understood that what exists on record is information. He was applied to the public information officer, he doesn't need a form. He can take any plain piece of paper and handwrite it, computerize, print out, or a typed one. And he must seek information only. That is all that can happen. So therefore, he used this. He understood all this and moved on. After a few days, he got a job. And then he needed a ration card. So he went to the rationing office, gave his application. As he was walking out of the door, the peon accosted him. And the peon said, "Aapko ration card chahiye kya?" He said, "Haan bhai, isliye to form bhare." The peon said, "Chai pani lagega." This boy said, "Theek hai, aapko chai pila dunga." The peon said, "No, chai pani does not mean chai pilana. You'll have to pay 2,000 rupees. This boy, without batting an eyelid, gave an answer. He said, "I will not pay a bribe. Main ghoos nahi dunga. I shall not give a bribe." The peon shrugged and said, "Stupid idiot coming from a village. He doesn't know how cities work. He will never get his ration card. Tum jao jao. You don't need a ration card." This boy went back. He found out from others in the basti that people were paying bribes and getting their ration cards in about 40-45 days. He waited 3 months and then he filed this RT application. And given an application for ration card on 5th August 2006, photocopy of receipt attached. I want the following information about its progress in the following format. Date on which application received, name and designation of the officer receiving it, action taken, date on which forwarded to next officer. There will be as many rows as number of officers who handle the application. Now, this information has to be there. He wanted to know, why have I not got my ration card? But if it asked that, there will be nothing on record. It would not be on record that since he refused to bribe, he was not given. Number 2, I want a list of ration cards issued in the last 2 months, giving the dates on which the applications were made, the dates on which the ration cards were issued. Now, both these are information which should be available on record. What could they tell him? Your file has not moved at all because you have not given chai pani. And the list would show that others have been given Intelligently, it framed the RTI application. Next day, the peon came to his house and said, the rationing officer has called you. He went to the office. As soon as the officer saw him, the officer said, अरे अरे इनके लिए एक कुर्सी लेके आओ और इनका राशन कार्ड लेके आओ और एक कप चाय और एक गिलास पानी लेके आओ. He did not give chai pani, he got chai pani instead. And to me, that one cup of tea was respect for the individual sovereign citizen of this nation. That is what it means, far more than the information, far more than his ration card. I repeat, this is not a grievance redress mechanism, but quite often there is pressure when people are acting illegally, and that leads to redressing of certain grievances. Of course, his right to information still remained. I'm not very sure what he did. This kind of format and this kind of information has been sought thousands of times. Ration cards, income tax refunds, other bookings, jobs, and so on and so forth, and has elicited similar responses quite often. This is another RT application that I want to show to you. This demonstrates how powerful the RTI Act can work at times. There are very good government officers, honest government officers, but they are not able to deliver because the system doesn't back them. If systems were backed and supported by Indian citizens, it could bring a sea change. And this is one of such examples. This is before I became a commissioner. I was just an ordinary citizen of Mumbai doing various jobs. And also talking of RTI and teaching people RTI. One fine day, in the morning, I saw on the front page of Times of India a photograph of Mumbai citizens demonstrating because a minor had been raped by one police constable More. On the same day, on page 5, I saw a small news item. The small news item said that one police inspector, Prakash Avare of Mumbai Police, had raped a minor the earlier year. The evidence was clear. He was suspended from service. When the case went to court, the court did not find him guilty, and therefore he was released. And he was being reinstated in the police service. When we read such things, we feel angry. I also felt angry, and I decided to use RTI. Description of the information required. According to a news report in the Times of India dated 29th April 06, Inspector Prakash Avare was accused of raping a minor girl in September 2005. He was acquitted by the Sessions Court in February and has been reinstated in service. I want a photocopy of the order reinstating him along with the file notings based on which the decision was taken. I didn't say, why have you reinstated him? I only said I want a copy of the record. The PO refused and I filed a first appeal to the First Appellate Authority, etc. Grounds for appeal. Facts of the case. I had asked for information regarding the reinstatement of Inspector Prakash Avare as per the attached application. The PIO first sent me a letter stating that the information would be provided by Bhaikala Police Station. PIO Bhaikala replied by his letter of 16.5 that the information could not be provided as it was exempt under Section 8(1) Retd exempts information which would impede the process of investigation or apprehension or prosecution of offenders. Grounds for appeal. PIO has not shown how providing the information could impede any investigation. In fact, no investigation is being held since Prakash Avare has been reinstated. The rejection is without any basis in law. Generally, for a first appellate hearing, they call the applicant. There's a very good Deputy Commissioner of Police. I don't recall his name, but he understood what I was driving at. As I said, I was just an ordinary citizen in 2006. So he said, Mr. Gandhi, I understand what you are doing, but the court has released him. What could we do? I said, sir, from my perspective, I'm only asking for a copy of the record. And B, there are two possibilities. Either Prakash Avare is guilty of the crime he's alleged to have committed, in which case reinstating him is gross disservice to the citizens and to the rule of law and to the police force itself. Alternately, he may be innocent. If he's innocent, somebody framed him. Someone else should pay for it. Ye kya hua? Kuch hua hi nahi, and everybody goes scot-free. He saw the point and he said, Mr. Gandhi, let me see what I can do. In 20 days' time, I got it in writing from the Police Commissioner of Mumbai that Police Inspector Prakash Avare had been dismissed from service. That is the power of right to information which one individual citizen can exercise. A police inspector was dismissed. largely because of the very good Deputy Commissioner of Police who must have worked behind the scenes to get him dismissed. But such things can happen, such things do happen. Citizens need to do something about it. If you just sit back and say, Kuch nahi hoga, nothing is going to happen. Summary for the central government, no specified format for applications and first appeals, useful to use the Maharashtra format. Application fee ₹10. Most convenient to attach an Indian postal order of ₹10. No fees for appeals. For second appeal, please check rules at cic.gov.in. Online RTI application and first appeal can be filed at, I've given 3 or 4 states. Some other states may also be offering it. Please take a look. Or even if on Google you type name of state and RTI online, you may discover that RTI onlines are, and there you can pay your the fee by credit card or net banking or UPI. This is a very powerful tool given to Indian citizens. Nobody's done us a favor. This right existed the day the Constitution of India was made and Article 19(1)(a) came into being on 26 January 1950. But there was no codification of this law, and therefore we had no practical means of getting information from the government. If you had asked before the law, it was a very laborious process. Some people had gone to courts and got information, but it was a very, very laborious process, as I said. The law, in my opinion, is one of the best laws in the world. I've studied some of the other laws, interacted with some of the other countries, and I can say with great pride, Indian Parliament has given us one of the best laws in the world. But in terms of implementation, our implementation is very poor. That is because information commissioners are not doing their jobs well. Courts are also not taking pro-transparency positions, and citizens are being a little lax. If you are the sovereign of this nation, you owe a responsibility also. Shivaji Maharaj or Akbar Badshah, when something went wrong, did not say, I am the ruler, I will only exercise authority. They said, setting it right is my responsibility. Setting India right, setting India's governance right, making our democracy work is your and my responsibility individually. Individually, not necessarily as a group. हम सब नहीं, मैं जिम्मेदार हूं. I was talking like this, and at one talk, one gentleman my age got up and said, Mr. Gandhi, ये सब बोलने को तो ठीक लगता है, अच्छा लगता है, चिकना चुपड़ा लगता है. मैंने बहुत आरटीआई एप्लीकेशंस की, मैंने बहुत कंप्लेंट्स की, मैंने बहुत बार रिप्रेजेंटेशन किया. इंडिया में कुछ होता ही नहीं है. Nothing can happen in India. To such people, I say, many of us go to mandirs, masjids, gurdwaras, churches, agyaris, wherever you. When you go there and come out, does a 100 rupee note extra fall in your wallet? The answer is no. You become more handsome, younger, more intelligent, something visibly happens to you? The answer is no. Then why do you do it? We do it as an act of faith. We have faith that by doing this, something good will happen to me, my family, my society, my city, my nation, wherever it is. What do we do for the nation as an act of faith? Zero. Let us try this as an act of faith for the nation. A survey of mine shows that all Indian citizens crib for 2 to 3 hours every month about what is wrong with India and its governance. Politicians are bad, police aisa hai, minister hafta khata hai, roads are bad, and so on and so forth. Does that cribbing change anything? The answer is no. Nothing changes. Nothing will change because of your cribbing. आजकल बहुत पेट्रियोटिज्म की और नेशनलिज्म की बात चलती है. It's good to salute the national flag, to feel pride in the flag, to sing the national anthem. Let me put a proposition to you. Supposing the entire nation, all citizens decided from one day for a 12-hour period from 8 in the morning till 8 in the night to stand before the national flag, eat nothing, drink nothing, just keep singing the national anthem. Would anything change? These are useful symbols. But we need to do something. Patriotism is feeling the need to change my nation, to make it better, to change the governance and to feel responsible. If you are the ruler of this nation, you have a responsibility to make it better. I hope you go back feeling that you are the ruler of this nation and feel the sense of responsibility for that. I have a simple slogan that I'd like to share with you. Mera Bharat Mahan hum kehte hain. Quite often we write, we say, Mera Bharat Mahan hai, but we don't really believe it, do we? Therefore, I say, Mera Bharat Mahan nahi hai. Mera Bharat Mahan nahi hai, par ye dosh mera hai. I, the individual sovereign citizen of this nation, am responsible. मैं इस देश का बादशाह हूं और मेरी जिम्मेवारी है, अगर ये देश बेहतर नहीं है, इस देश को बेहतर बनाना, ये मेरा देश प्रेम है. Thank you very much, friends. Yeah, I'm done. Thank you.
So, Mr. Gandhi, you have, in a very subtle manner, you have explained what can be done. Like you shared, we will take one of the workshops. What are the exact procedures? Because today was a hurricane knock within the T20 itself. So, what should be the procedure to inspect the records of sale, lease deeds registered on a particular day in the sub-registrar, and then, if required, take photocopies?
I have the format of inspection that I've given. In that, say, I want to inspect records relating to whatever subject or time, or give a description of that. Give a slightly wider description. Don't give too wide a description. If you're not very sure, give a slightly wider, but slightly wider. Maybe the first time you may not get it right. Second time you would get it. You would understand there's some technicalities. But a simple RTI application can get you inspection. And normally, as I have suggested, ask for 2 dates with time. And you pick one of those and go there and inspect. This is fairly simple. Inspection is a right given to citizens under RTI. And I have the format also in the applications.
This is by Padma Bhan. No case number has been given by the State Information Commissioner for second appeals filed last year. What can be done?
That is a weak point. Unfortunately, the commissions, as I said, are not really responsive, are not really fit to do that. Many of them, not all of them, but a very large number of them are not fit to do their jobs. And this is something which I find in not just information commissions, in Human Rights Commission, Women's Commission, Children's Commission, Lok Ayuks, Lokpal. Lokpal, we had lakhs of people on the roads saying we want a Lokpal. Over 2 years now since we've got a Lokpal, what's happened? We are not taking accountability from these bodies. We need to find a way of putting pressure on them. This is wrong. When I was a commissioner, I used to ensure that 99% of the cases were disposed in less than 3 months. In my opinion, if it is not disposed in 60 to 90 days, RTI becomes right to history. But we need to build sufficient citizen pressure. The high courts in Karnataka and Calcutta have given decisions saying that commissions must give decisions within 45 days. That's not being implemented. I have filed a PIL in Bombay High Court asking for this to be implemented. But I think if nationally, in various states, we file applications, we file PILs, maybe we'll get a better response. We need to make the commissions work properly.
Can companies seek information under the RTI? And does private insurance companies come under the RTI?
Private insurance companies are unlikely to come unless you can show that they are subsidized by government or government has actual control. But information they file with the insurance regulatory authority can be accessed.
If this is by Krishna, if RTI application is rejected on an inappropriate ground by the IO and appellate authority holds it appropriate, is there any provision for punishment for the IO in the addition to information?
IO being the PIO or the first appellate authority? Sorry, PIO. Yes, there is up to 25,000 rupees, 250 rupees per day of delay, going up to 25,000 rupees. And if the denial is recurrent, if somebody is known to be like this, then disciplinary action can also be recommended against him. Also, compensation can be awarded to the applicant.
Once RTI copies of the investigation report was given only 19 out of 300 odd pages. Cop saying given the rest of the copies will get into trouble. This question is incomplete.
Sorry, I didn't understand.
No, that question was not very happily worded. On the platform I've taken this one. How to ask complete records for investigation report of an FIR that was closed as a B report.
Sorry, come again.
How to seek an information in respect of an FIR where the closure report has a report has been given.
Ask for it specifically. Say what you want. Whatever has been stated is what you need to state in your RTI application, that I want to see records or I want copies of records of this FIR.
And this is by Murli. What if a file is damaged by floods or fire before this act is being enacted or later on also?
For that, there's no real solution, but sometimes it is possible to reconstruct files. So you can say that reconstruct the file, but that's a dicey thing. It's not, there's no universal thing. If a file is damaged, as I said, information has to exist. If it doesn't exist, it's not information.
Can an advocate seek information on behalf of the client for any information under the RTA?
You don't need a locus standi. Therefore, why should you file it why should an advocate file it on behalf of somebody else? Any citizen of India can ask for information. Companies, etc., cannot ask for information. By law, they are not entitled to information. This is a fundamental right. Fundamental rights belong to citizens of India. But there's no requirement of locus standi. Only exception I would say is supposing you are asking personal information of a client as a lawyer. What you can do is, if you want the lawyer to ask for information, he can give a copy of a no objection from the individual and do it otherwise. But there's no such requirement of locus standi at all. Therefore, in most cases, you do not need to represent anyone.
It says.
Also, Vikasji, I'd be very happy if people challenge what I'm saying. I would very much welcome that. If you do not agree with me on the meaning of the law, on whatever I have said, please challenge me. Go right ahead and let's have a discussion. I'm quite open to it. I have no hang-ups like that.
The only reason normally the applications are filed through the lawyer's office is because they feel that sometimes there is too much delay in the appellate authority, etc. So the office of the advocate can handle it. That is one of the fundamentals I've seen that the advocates are handling. Because it becomes
then the advocate can file it on his own name.
Yeah, that's what he means. That's what he's saying. Advocate or it's his name, clerk's name.
Instead of saying that I'm filing it for somebody else, say you are filing for information. End of story.
This is by Dhyan. Whether we can seek access to a pending document before 10 years through RTA. What is the time limit?
1,000 years. If a document exists, you can seek information. There is no time limit. One thing, since the time limit has been mentioned, after 20 years are over from the event, 7 exemption clauses do not apply. Only 3 exemption clauses apply, A, C, and I. 7 exemption clauses, it's like the Amitabh Bachchan, Kaun Banega Crorepati. You can drop some queries. Similarly, in this, after 20 years, only 3 exemptions will apply, 7 exemptions do not apply.
This is, I want to send an RTA form to the sub-registrar Bangalore. According to a website, other than 10 rupees in the IPO, additional 1 rupee per sheet must be paid. How to pay that, sir? How will I know?
No. As I explained, you file your RTA application with the application fee. The PIO has to inform you how many pages, because you cannot know how many pages it is. So the PIO will send you a letter saying the information is so many pages, please pay so much money. After that, you make the payment. Is that clear?
Yeah. So, by Dilip, whether it is mandatory or directory for a state information commissioner to hear a third party as per section 19 subclause 4 of the RTI Act before taking decision, and if there are any citations in this regard.
If there is a feeling that third party is involved and information may be considered confidential, then there is a need to call the third party to give his objections. But the objections has to be based not saying, I don't want to give the information. The objections have to be based on section 8.1 only. The third party gets an opportunity to show that it is exempt. It does not mean he gets a veto.
Chandrasekhar, if the PIO fails to take action in the appropriate manner under the RTI Act, can we initiate IPC proceedings against him for failing to implement the law?
See, I've heard of a lot of people saying, I do not claim to be an expert on IPC, but I have not yet come across any such instance. A lot of people have talked of taking action in the IPC, but I am not aware of any actual action having been taken. So I would not comment on that.
Is there any way / provision we can get the RTA within 30 days? We have come across where the PIO deliberately delayed the matter.
See, the whole system as planned in the law is that PIOs will be scared of penalty provisions. Very often PIOs are not scared because the commissions are not working and citizens are not putting enough pressure on the commissions. So therefore this anomaly comes in. If commissions give decisions within 3 months and penalize people when they do not supply information, this will be a completely different situation, and that is where we need to build pressure from the citizens.
Rajkaran, can I see Rajshekharan, can I seek information regarding my own bank account of my bank transaction, since bank had denied to give this when the letter was given?
Definitely, you can seek information on this and say that I have no objection, and you cannot claim that this is personal information or fiduciary relationship, since I am the fiduciary.
Last question, section 7.9 of RTI Act disproportionately diverged these force and hence denied the information by PMO. Information requested number of grievance about the police atrocities in a particular year. What is the manner to handle it?
7.9 is not a rejection. 7.9 says you should give it in a different form. So if it is excessive time requirement, then the PIO should offer either a few thousand pages of information and say you pay 2 rupees and extract the information, or offer inspection of documents.
So, we have taken the questions of whatever it has come forth, and we will share the PPTs shared by Mr. Sailesh Gandhi in the groups. And tomorrow at 4:30, we will be having amongst us Justice Ramkumar, the essentials for valid execution of an unprivileged will. So do stay connected with us tomorrow at 4:30, and we will share the questions of Justice Ramkumar, which he will be taking, because we all know, those who have been connected with this webinar, that Justice Ramkumar takes the common questions which come in the legal way as well as the factual aspects. So do stay connected with us. And if you are not a member of the WhatsApp group or a Telegram group, do join us. And you can also like, subscribe, and share the YouTube channel of Beyond Law CLC. And thank you, Mr. Gandhi, for sharing the insights. It is a pleasure to be with you. And we will do some more webinars on the workshops. Thank you.